Deputy Chief Justice, thank you again for talking to us from Anchored in Law.
Thank you.
Just a question about when judges, or when a person gets appointed onto the bench, whether that person loses his or her right to have an opinion and express it publicly. I mean, judges are human beings. They are citizens of the country. They have political rights. They vote. And they have opinions about what's going on in the country. What would your view be to someone who says a judge may not express his or her own, say, political opinion or socio-political or socio-economic opinion about where the country is going, for example?
No, thank you. I don't think that a judge, upon being appointed, completely loses his right to express himself on matters affecting a country or on matters affecting society. But I think that a judge needs to be careful in choosing matters on which he may or she may express publicly a view. And he or she needs to be cautious because of the position that he or she holds. It might be difficult to make a list to say these are the matters where he or she should be slow to get involved. But I think as a principle, I don't think that the position is that upon being appointed as a judge, a person becomes completely banned, as it were, from expressing a view on certain matters publicly that the public is interested in. But one needs to be careful, one needs to be cautious, and a judge should not make it a habit to express views on certain matters, publicly. But certainly, I don't think that one can talk of a complete ban.
Yes. Well, you're reluctant to advance an example. Let me give you an example. Dr. Frederick van Zyl-Slabbert, some years ago, was commissioned by the government to prepare a report on the effectiveness or efficaciousness of our present electoral system. And he produced a report. Now, there are many in the public space who decry the current electoral system and says it's not a true reflection of what the views of the electorate is. In other words, the electorate is not effectively represented simply by voting for a party. There are people who are saying, well, we should vote for the president directly or vote for legal representatives directly. Now, is that the kind of thing that a judge shouldn't be able to comment on?
Well, I'm not sure precisely if one picks a particular, example, because one needs to look at that carefully, and it may well be that one would need to look at certain matters at an issue like that much more deeper. But I think at a general level, I would just leave it at saying, I don't think it's a complete ban, and probably each case must be looked at on its own against the background that the judge must remember the position that he or she holds, and that she or he mustn't make it a habit of, venturing opinions publicly on certain matters. But I wouldn't want to go and be specific. One would need to look at such matters quite much more closely
Okay, and so on a case-by-case basis, it would be up to the Judicial Service Commission to decide whether that was appropriate or not in the event of a complaint, for example, arising.
Well, obviously, a complaint would relate to a specific, comment, and a specific comment would relate to a specific topic, a specific issue. It may well be that further reflection and deliberation might produce a yardstick to say this is how you distinguish matters on which a judge may public express an opinion on in regard to certain matters. So it may be that one could end up with that, but that might need more reflection and more deliberation.
Yes.
But certainly, judges must be cautious, but I don't think that there's a complete ban.
Yes, okay. Thank you for that, DCJ. Now, let's move along to something that happened last year at the event or at the occasion of the launch of the inaugural annual report of the judiciary, I think it was, by the Chief Justice here in this court.
Yes.
It was the first time that it was done, as I recall.
Yes, it was, yeah.
Now, during that event, the Chief Justice cautioned judges for, as it were, sacrificing justice at the altar of public opinion. I'm paraphrasing.
Yeah.
Now, sitting where I sit as a practitioner who appears in the various courts and, of course, alive to public opinion, one does see certain instances where one would say, well, that seems to be playing to the gallery by the bench. There are other colleagues who, looking at the same event, would say, no, that is not acting to the public gallery, that is applying the law as it should be applied. In your observation, without pointing to specific examples, what is your general sense of how the courts are approaching that, how should I put it, that competition between dispensing justice on the one hand, but also trying to please the public opinion, because after all, justice is not dispensed in vacuo.
Well, I think that my own observation is that in many cases, overwhelming majority of cases, I don't get any such sense. But I agree that there are few occasions where one gets the perception, and one can put it no higher. You see, you wonder whether there is, excuse me, you wonder whether there hasn't been an influence of some pressure of one kind or another. But those where one would get that would be very few, very, very, very rare occasions as far as I'm concerned. The overwhelming majority of cases, I don't get that perception. And even talking to the public, of course, one doesn't do a survey. One doesn't do a survey, but one does know that, one comes across a lot of people who have confidence in the judiciary. But of course, you do have, you do hear, you see in the media, you see on TV, you see articles in newspapers where a particular community is very unhappy with a particular judgment or decision of a court, and they make allegations about what they think, why they think that decision is made. So one does get that. But I think that what is quite important is for the judiciary to be alive to the fact that the way they make decisions could give rise to certain perceptions. Mm-hmm. But that is not to say that because you don't want people to have certain perceptions, you must then make a decision that you otherwise would not make. Mm. You must make a decision that is in accordance with the Constitution and the law as you understand it and as the evidence before you suggests, you know. Mm. But it is important that we do not create any fertile ground for perceptions that sometimes some judges might be giving judgments that are basically based on pressure from certain interest groups or that seem to seek to be biased in favor of certain interest groups. Yes, yes. So it's very important. In the end, every judge must be able, once he or she has given a judgment, to say, in my conscience, I'm quite clear that I've given a judgment that, as far as I understand the Constitution and the law and the evidence before me, accords with that. Yes. You know, that's the bottom line.
Okay. Judges, as we all know, are human beings. They have opinions, they read newspapers, they watch television, they talk to people in the country. To what extent is a judge influenced by what he or she hears or reads about in the media, or I mean, I hesitate to call it a popular narrative, but there are certain issues where a country seems to be gravitating towards a particular direction on a particular issue. And it tends to be overwhelming at times, that you see every newspaper you open, this is the angle that it is taking on a particular issue. Every time, I don't know if you're on Twitter, every time you open social media, you see a preponderance of opinion leaning in a particular direction. Now, if a judge is exposed to all of that, to what extent can he or she not be influenced by such maelstrom, if I can put it like that?
Well, I assume that when you talk about a judge being influenced, you mean a judge being influenced by what they hear in the media, what they read in the media, and what they see on social media, where that ends up influencing their decision in matters.
Correct.
I mean, what is true is that judges read newspapers, judges watch TV. Well, I'm not on Twitter, but I'm sure there are some judges who are on Twitter. And judges speak to people in society. The judges have got neighbors, judges have got friends. They sit and they talk about soccer, about cricket, and about all kinds of things.
Kaiser Chiefs and
Kaiser Chiefs, exactly. they do. But I think in terms of, at a factual level, to what extent that influences judges, my own view, my starting point would be that every judge knows or should know that when they decide any matter, they've got to decide a matter in accordance with the law, Constitution, the evidence. And therefore they need to, as far as it is humanly possible, to disabuse their minds of anything else that falls outside of that, or that may fall outside of that. Now, whether, to what extent, what one reads in the newspapers and hears in the on TV and hears in social engagements might be difficult to say. But I would simply say that it's important that when a judge then deals with a matter and he or she is aware of such views that are expressed in the media, and some maybe seem to be very popular, they must just remember their oath of office. They must remember their oath of office.
To dispense justice without fear,
without favor, or yes,
Now, can I give you an example?
Yes, yes.
TCJ? In the country, the sexual offenses are regarded as very serious and prominent in a negative sense.
Yeah.
There is a lot of it going on, and there's a lot of outrage generally in the country about sexual offenses in the country. Now, I haven't done a study as regards what the sentencing is. I mean, I don't practice criminal law, but I understand there is such a thing as minimum sentence regime and so on.
Yes.
Now, I don't know what your sense has been well, let me phrase this question this way. Surely, a judge who is hearing a sexual offense case, mindful of the wave that is sweeping the country and the mood in relation to sexual offenses in the country, cannot escape being influenced by such.
Well,
whether in, let's assume the conviction has come, but certainly to send a strong message that this is not acceptable and it ends here. Surely that must reflect in the sentencing.
Well, put it this way. A judge who deals with, who is presiding in a trial involving a sexual offense, rape, whatever, needs to know that in the end, he or she must dispense justice. And he or she must do so, as we were saying a minute ago, without fear, favor, or prejudice. The accused must also feel that he, or also she, it's mostly he, he has been dealt with justly. As far as possible, he mustn't leave the courts into the cells with the idea that the judge may be sentenced or found him guilty because of pressure from the community and so on. And the judge, as far as finding whether the accused is guilty or not, must look at the evidence before him or her and nothing else. When it comes to sentencing, there are a number of factors that a judge must take into account. And I think those factors were framed in such a way that the judge takes into account the interests of the accused, the seriousness of the crime with which the accused has been found guilty, as well as the interests of society. And as I understand it, the judge needs to look at all of these to say, what would be an appropriate sentence. So in other words, he or she can't just look at one of these, like maybe there is a complete outcry there to the detriment of the other considerations. He or she has got to look at all these considerations that must be looked at and be able to come to answer the question in the light of all of these legitimate factors that are made take into account. What is the appropriate sentence in regard to this accused, in respect of this crime, in the light of, I mean, in some cases, courts take even into account whether the particular crime is prevalent in the area, in order to deter others. So within those bounds, so the judge has got quite a large, a wide discretion.
No, Deputy Chief Judge, I appreciate that answer, but with respect, it does sound like an answer to an exam question for which there's a tick box exercise and you get your marks. But we all know there is such a thing as an inarticulate premise. Which is why there are some judgments are overturned on appeal in a higher court. Because a judge would have taken all these factors without any bias, seemingly. But then the higher court disagreed, and yet they all applied the same principles and factors. But I don't want to exhaust this question or to dwell on it too much. But there is a sense where, depending on where the judge grew up, what the judge has experienced in his or her own world, where that judge, applying the same factors to which you adverted, would arrive at a particular outcome.
That is true. No, that is true. That is true.
And then another judge who grew up in a different environment.
No, that is true.
And have had different experiences, applying the same factors and principles would come out to in a different thing. With a different sentencing regime. Now, you could, for example, have a judge giving a rapist 15 years. And another giving a rapist 6 years. But they applied the same factors. Now, I know it may sound like an unfair question, but what would have influenced the one judge to give twice the number of years in sentencing to the same person in relation to the same offense, the same circumstances, but applying the same factors? Is that a fair question?
Well, no, it's a fair question. Well, it's not just about sentencing. It may be about a number of things. I mean, what you are saying is very true. You could have different judges giving vastly different sentences in the same case, and it does happen, A judge or magistrate gives a sentence, and then if there is an appeal, the appeal judges want to increase the sentence, and they are not supposed to increase it unless they think that the sentence that was given is just too inappropriate, So it does happen.
Evokes a sense of shock.
A sense of shock. But it's not only about sentencing. I mean, you and I have been involved at some stage or another in labor law matters. If you look at what is fair, you talk about dismissal, what is fair, different people will give different conclusions about whether a particular dismissal is fair or unfair, and they have the same facts,
And they apply the same principles.
They apply the same principles,
But they come from two different worlds.
They come from two different, worlds. But sometimes, even when they come from more or less the same, sometimes that is what happens. So it may be that it might, on some circumstances, have to do with one's sense of what is fair, in a particular case, and fairness in this regard would apply to dismissal disputes, for example, as well as in terms of a sentence in a criminal matter, because as a judge, when you sentence, you are trying to be to give a balanced sentence. Yeah, you say, you know, what does society, expect? What is fair? But you say, I must have due regard to the personal circumstances of this individual. So it might be difficult to define what it is that gives rise to that, but probably there are many areas of law where that happens. And now, as I speak, actually, even if we get out of criminal law and labor law, we get to delete about what is reasonable, for example, what is reasonably foreseeable. You know, there are a number of areas where different judges will give different views.
No, I appreciate it.
Yeah.
Thank you, Deputy Chief Justice. Now, the final question relates to commissions of inquiry. Now, I must try and tread carefully here because I know you're currently chairing a commission of inquiry.
Yes.
The President has tended to appoint judges, but not excluding judges who are in active service. Yourself, for example, are in active service. Now, a question that arises is, once a judge who is in active service is taken away from the court of which he is part to go and sit in a commission of inquiry that's going to run for a year or 2 years, doesn't that create an inefficiency, if you like, in the court from which the judge has been taken? Because now that court is one judge short, which means that some acting judge is going to be appointed to act in his or her stead. And of course, as we know, a senior judge, an experienced judge in a court such as this is not easily replaceable. No acting judge is going to fill those boots, but they can do their best, of course. Now, doesn't the court then become the poorer for a senior judge, such as yourself, being away from the court for a prolonged period like a year or two, chairing a commission of inquiry?
Excuse me. Well, let me start off by saying that my observation is that in recent times, the tendency seems to be to appoint retired judges. The Marikana Commission was chaired by a retired judge, Judge Falam. The Higher Education Commission was chaired by a retired judge, Judge Hare. Recently,
the
Nugent Commission, Judge Mtiane finished last year in December, I think, a commission. He is retired, a commission which related to remuneration of public servants. He was on that commission for two years or so. Before that, as I understand it, the former Chief Justice Ngobo had been appointed to that commission, and he had already retired, but he resigned, and then another judge had to be found, and the retired judge was found. So I start with those observations to make the point that I think that the tendency in recent times has been to appoint retired judges. Now, where a sitting judge is appointed, and in answer to your question, my view would be that where a sitting judge has been appointed, whether you say the court would be the poorer without the judge or not must depend on a number of things. Simply because it's a senior judge who is not there, and there may be an acting judge coming in. On its own, ought not to be decisive. You know, there are people bring different things on the table. You know, you can get an acting judge from the High Court, one of the High Courts, get an acting judge if it's a constitutional court, for example, from the SCA. Those people could bring a lot of value, their own experiences, which can be quite helpful. I have known that some of the colleagues from the High Courts and the SCA who have acted in this court, in the constitutional court, when one or other colleague is on long leave. I know some who have made very, very important contributions. So I think that one should look at a number of things. One is, it is important that judges from the High Courts and from the SCA get a chance to act, for example, in this court, because if later on there are vacancies in this court, and then they would be part of the pool, which is good for the court as well, especially against the background that we have, where on some occasions there simply weren't enough candidates for positions in this court. But those people might not have exactly the same experience that I have, or any particular judge of the constitutional court, for example, have, but they may be bringing in a lot of other experience which is important to the court. So although on the face of it, it might be seen as if the court would really suffer, I would say we need to look at the broader picture. And the broader picture is not just about the court also, it's also about society. How is society served? The society is also served when we create those pools, so that going forward there could be a lot of people that would be in a better position to fill positions here. So I wouldn't be too concerned. I would simply say that we must recognize that different people bring different experiences.
Yes. No, thank you, Chief Justice. Just one last sideways question. There was, I'm not sure if it was a commission of inquiry or simply an inquiry, where former Deputy Chief Justice Moseneke was appointed and Justice Khampempe to do a report on the Zimbabwean election.
Yes, I think it was not a commission of. I think they were said to be. There was a word used, if I'm not mistaken. They were like a miser. I don't know, but there were special envoys or something.
So that was not a commission.
Not a commission, as far as I remember.
Deputy Chief Justice, thank you very much for talking to us at NCAD in Law.
Thank you very much.
We really appreciate that.
You're most welcome.
Thank you.
Thank you.